Hear ye, hear ye, hear ye. The Colorado Court of Appeals is now in session.
Good afternoon. Please be seated. Welcome to the Ralph Carr Center in Division 3 of the Colorado Court of Appeals. We have two cases on our 2 o'clock docket. Counsel, for our second case, are you here and present? Mr. Lofgren is? Other counsel's not. So we'll go over this. Oh, okay. If you have questions when your case is called, we will go over that, but these instructions will apply uniformly. My name is Judge Dunn. I will be presiding today, and serving with me today are Judges Yoon on my right and Moultrie on my left. Counsel, I know you've received our instructions on oral arguments. Do you have any questions about our procedures?
No, Your Honor.
Okay, great. And for counsel, as well as our visitors today, I would just ask, if you're not using an electronic device for your argument, if you could turn it off. Not just silence it, because it does interfere with our recording equipment. So I would appreciate that. Thank you very much. And counsel, I believe you know your experience that everything that is argued today will be available on our website. It's being live streamed. It's available in perpetuity. So if there's anything confidential or sensitive, just be aware of that during your arguments. And with that, we will call our first case today, which is Nash versus Mikesell. And I apologize if I mispronounce Mikesell. Counsel, whenever you're ready.
May it please the court, Steve Mashaki arguing for the plaintiff taxpayers. The dispositive legal principle in this appeal is that a sheriff can enforce civil immigration law only to the extent consistent with state law. In other words, if state law forbids it or doesn't authorize it, the 287G statute doesn't authorize it. Here, the Colorado Constitution and Colorado statutes prohibit arrests and detentions without a warrant signed by a judge, specifically prohibit arrests and detentions based on any ICE form, and require release of persons who've been granted bail and posted bond.
So can I ask, do you agree with, I think this is how trial court framed it on page 17 of its order, is whether the 287G program violates section 2476.6102?
That's one issue, Your Honor.
What if we conclude that the program violates that statute and that 8 USC 1357G doesn't allow DIOs to violate state law, do we really need to address any other issues?
No, I don't think you need to reach the constitutional issues if you decide the statutory issues in our favor.
Okay, do we even have to address whether the ICE form I-200 complies with state law? Because as I read the statute, it says, a law enforcement officer shall not arrest or detain an individual on the basis of a civil immigration detainer request.
Correct.
And your whole argument is that a judge didn't sign it.
Correct.
And if we conclude that a law enforcement officer shall not arrest or detain, and it falls within the form I-200 falls within the civil immigration detainer, do we have to address any other issues?
I don't think so, Your Honor. Again, we have two constitutional claims and a statutory claim.
Yep.
And if you decide that the sheriff's arrests and detentions based on Form I-200 are prohibited by the statute, I don't believe you need to go on and address the constitutional issues. I would like, though, to...
Oh, well, counsel, let me dovetail on that. Because one of the arguments, as I understand it, is the sheriff didn't have authority to enter the agreement. So if there was no authority in the agreement, we were to hypothetically conclude it was invalid. Does that end the inquiry?
I think it does, to the extent that the sole basis, so the sheriff is admitting here, if you recall from his briefing, that non-DIOs, non-287G officers can't serve immigration warrants. Only it is the purported authority provided under a 287G agreement that supposedly gives DIOs this authority to execute these warrants. And so I think I think you're correct that if you decide that the agreement itself is invalid, then there would be no basis for the program at all or for the DIOs to serve warrants. That's the only basis that the sheriff is arguing. He's not arguing there's authority from anywhere else.
But wasn't there an argument? I'm sorry.
No, go ahead.
Wasn't there an argument about general authority under the sheriff's peacekeeping duties to enter into these agreements?
Yes, there is. And the peacekeeping duty, Your Honor, doesn't allow the challenge practices as a matter of both fact and law, but the legal reason more than suffices. Colorado sheriffs are limited to the express powers that they have by statute and any implied powers that are necessary to effectuate those express powers. The sheriff can't do what Colorado law doesn't authorize or forbids him from doing. And here, again, our Constitution and the statute in question forbid him from arresting or detaining persons for civil immigration purposes. And so the general peacekeeping duty cannot supply the authority that's missing in Colorado law otherwise.
So, Mr. Mashaki, so with respect to the 287G agreement, though, it's broader than just arrest or detentions, is it not?
It is broader than arrest or detentions, that's correct. But virtually, I mean, in his briefing in the court below, Mr. Hercom characterized what we have challenged here as sort of the core law enforcement functions or the essential law enforcement functions, and we have as well. So the arrest and detention are the core components of this program.
With respect, I guess my next question then is, even though your argument is that the arrest and detention are core components, there's information from the trial court, from the briefing in this case, is that part of the purpose of potentially these agreements is also to assist with investigative functions related to immigration enforcement. Is that correct?
Yes, that's correct.
Is that taking place, or do you know whether that has taken place under this agreement?
The only investigative functions, if it were, is essentially there's some testimony with respect to the DIOs or other jail staff identifying whether people were born out of the country. And that itself was enough to trigger putting a detainer in their file and eventually an arrest. And the statute itself in Section 103 authorizes only one thing. It says that that peacekeepers, that sheriffs can, for example, arrange for an interview with an ICE officer if they provide certain disclosures to the person, but that's all that it authorizes. And that's what we would say is authorized. I think if I were to sum it up, Your Honor, what is permitted and not precluded by the statute and the Constitution is communication. The sheriff's DIOs and the sheriff's staff can communicate with ICE. They could communicate with a prisoner, but that's it. They can't go beyond that.
So, can I just ask, the scope of your lawsuit is just on arrest and detention?
We have asked for declaratory relief beyond that, Your Honor.
And what are the other beyond?
We have requested 5 declarations in total, and they are in at 1293 to 1294 of the court file, and we are asking you to remand for the trial court to actually enter all 5 of these declarations and enjoin the challenge practices, the arrest and detention based on the ICE forms. So we're asking for all 5 of these declarations. They include that his policies and practices under the agreement exceed the limits of authority that he has under Colorado law, that it doesn't authorize as DIOs to perform immigration functions inconsistent with Colorado law. And then we go through each of our 3 claims, and we asked for a declaration that our claims are valid and prevail.
So with respect to your request for relief, for the injunctive relief,
Yes.
isn't your position that really, well, I guess let me ask you this. Is your position is that what are we reviewing? I guess de novo versus abusive discretion. In looking at the trial court's order, the court didn't necessarily make specific findings, put under a header. These are the findings I'm making with respect to plaintiff's request for injunctive relief. There was a statement at the end that said, I don't think you've met your burden. So what facts would we be considering with respect to the request for injunctive relief, if any?
It's a very fair question. The court actually never went through and specifically analyzed each of our claims and rejected them. Had I not been barraged with questions, I was going to start off with Article 2, Section 7, because the court didn't say anything about Article 2, Section 7. And in Mr. Horcombe's brief, his brief was 1 page long on that issue. There's really nothing that responds to the very powerful argument that these are unconstitutional warrantless seizures under the Colorado Constitution. But you're quite right. The court didn't go through and specifically raise and reject each of our claims. It simply recited at the beginning of the order, here's the declarations plaintiff wants, here are the declarations defendant wants, and then at the end gave defendant their declarations. So what we're asking you to do is reverse the court's ruling, get rid of those declarations, and remand to enter our declarations and to enjoin and to have the court enjoin the sheriff from engaging in the challenge practices.
I guess that's why I'm a little confused. Isn't the challenge practice that they're arresting and detaining people, individuals who are eligible to be released? That's the challenge?
Arresting at all. Arresting at all, and also, and then, yes, detaining people who are entitled to be released, correct.
Isn't that the scope of the relief you want?
Correct. That's part of it, and anything the agreement authorizes that involves arrest or detention.
Okay, so that's why my first question was, if we conclude that the statute that I went over about arresting and detention is prohibited under that statute, that could resolve the whole case?
I think so, as long as you're also rejecting all of the sheriff's defenses. Because the sheriff has a number of defenses that he's raising to the application of the statute.
Okay.
And I'd like to reserve the remainder of my time, Your Honor.
You may.
Thank you.
Thank you very much.
Good afternoon. May it please the court. I am Paul Hercombe. I am serving as the Teller County Attorney, and I represent Jason Mikesell in his official capacity as the Teller County Sheriff in this action. And Judge Moultrie, you asked a question about the standard of review. The parties disagree on what the standard of review is in this case. Relying upon the Supreme Court case last year in the College America case as a shorthand for that case, it's a mixed standard of review. The trial court's findings of fact are reviewed on abuse of discretion standard, and then the conclusions of law and the statutory interpretation are de novo. In this particular case, the judge made very detailed findings of fact. His order is 26 pages long, including the header and the signature page. Pages 3 through 21 detail all of his specific findings of fact in the case. This is a case of first impression. This is the first time a 287G agreement has been analyzed, and the first time that witnesses have come forward to provide testimony about what they actually do underneath this program. And so the Judge Sells, the Teller County District Court in this case, entered in very specific findings of fact from the sheriff's testimony, the detention commander's testimony, most importantly, the DIO, the designated immigration officer, Lieutenant Laura Hammond. He had very detailed findings of fact where she explained the scope of her authority, which is limited under federal law, under the 287G agreement, and it is consistent with Colorado law, and the evidence at the trial showed how the narrow scope of the DIO is indeed consistent with Colorado law.
How?
Because it is the service of a valid federal arrest warrant. The plaintiffs in this case admit and concede the I-200 signed by an immigration officer is a valid federal arrest warrant.
It's valid under federal law, but isn't the whole issue, the plaintiff's whole argument is that it's not valid under Colorado law? And doesn't the section that, I'm sorry, it's escaping right now, but 1357 that authorizes 1357 that authorizes the 287G agreements, it also states to the extent consistent with state and local law, does it not?
Yes, it does, Your Honor.
So
And
how is that consistent with Colorado law?
it is consistent for a couple of reasons. First, a 287G agreement is not prohibited under Colorado law. The plaintiffs in this case want you to help remedy what they conceded at trial was an inartfully drafted statute.
Can you help me explain why it's not? It says a law enforcement officer shall not arrest or detain an individual on the basis of a civil immigration detainer request.
Yes, Your Honor.
Civil immigration detainer is defined to include warrant for arrest of alien. And I-200 form, which is titled warrant for arrest of alien, why doesn't it fall squarely within the definition?
Well, earlier in that definition, Your Honor, if you see the reference to the Code of Federal Regulations, I believe it is 287.7, that specific federal regulation cited in that statute only speaks to the I-247A form. And that is exactly the form at issue in the Cisneros case, which both parties have agreed has informed this case. We disagree on how it informed this case. But that, as a trial court found in this case, what you've just read, Your Honor, the critical word in that statute is the word request. We agree that if a non-DIO, like in the El Paso County Cisneros v. Elder case, if someone who is not trained, certified, and authorized by ICE as a DIO.
Let me back up. The 8 CFR 287.7, you're
Yes.
saying I-200 doesn't fall within the,
No, it does not, Your Honor.
okay, and what does it fall under?
That the statute cited by the Colorado legislature, excuse me, back up, the federal regulation cited in the definition does not include the I-200 warrant for arrest of alien.
Okay, what does I-200 fall under? What federal statutory authority is there?
It is,
Or the regulation?
I believe it is 0.5. I think it is 8 CFR 287.5. The judge in the case also cited the authority for a DIO. I believe it is, I'm going to get the numbers wrong, but it is cited in the trial court's order in terms of the federal authorization to an immigration officer who is authorized, does not need to have the warrant for arrest signed by a judge. And that has been the law for over 200 years in our country. This is an executive branch function at that level. Then under the 287G program, local law enforcement officers go to a lengthy training program. They're certified and authorized to serve an arrest warrant signed by a different officer. So it is the service of that arrest warrant that is at play with the 287G agreement. And that occurs inside the jail under the jail enforcement model, which is what this program is.
So I'm struggling a little bit because although I understand your point on the regulation that's cited, it does seem to read out of this statute a huge chunk of the definition, including a pretty expansive word, and it's obviously the warrant for arrest for alien is Form I-200. So while I understand the appeal of your argument, if we're playing the plain language, how do we interpret a statute to exclude a chunk of the definition?
Your Honor, you focus on the word request. and you compare that with a command from an immigration officer under the 287G program, remember under this program, the DIO may only exercise her authority under the supervision of an immigration officer. That officer signs the I-200. I believe I had my response brief had a copy of what that I-200 looks like. That's signed by a federal officer authorized by law to sign those arrest warrants. Then it commands an individual, such as a designated immigration officer, to serve that, to effectuate the arrest. It does not request. So if you compare this with the Cisneros case, in that particular case, nobody was trained under the 287, there was no 287G agreement. None of the jail officers were trained, none were authorized, and none were supervised. And in that circumstance, primarily the I-247A form was faxed or sent to that particular jail with a request to hold that person. The court in Cisneros, and I believe confirmed on appeal, or it might have been mooted on appeal, but the court in Cisneros found that that request was not a basis for a lawful arrest. That then got codified in the statute that we've been discussing, Your Honor. The difference here in the trial court, after hearing the evidence and understanding how the program works and how the various forms work, applied those facts to this and found that the I-200 to a DIO is a command, not a request. Interesting, in the court's order, the court specifically goes through all of the various forms mentioned in the definition of that statute. None of those other forms are used at all to detain anybody. One of them, an I-203, is simply a tracking document that allows a facility, typically under an intergovernmental service agreement, to then charge ICE a daily rate for housing that particular person. So the I-203 has nothing to do with the detaining or holding or arresting or anything. Likewise, the 247A alone cannot affect that. The critical distinction that the sheriff would like to emphasize is that this is a different program. It complies with and is consistent with Colorado law, because when these officers, the DIOs, are acting, they are acting as de facto federal officers. The case law cited in the briefs, the case law cited by the judge in his order, confirms that fact. In their reply brief, the plaintiffs cited a case out of Oregon and a case out of Minnesota. The Minnesota case, in fact, supports our argument. In that particular case, the Minnesota court compared the cooperative nature of an informal relationship, which is in subsection 10 of 1357, with a formal 287G agreement. And that court in the Minnesota court found that when you do have a 287G agreement, the officers who act under that are de facto federal officers. So at the beginning of our brief, I had two initial points. One was that these DIOs are de facto federal officers. We believe the facts in this case.
So what? It's still, that statute says you still have to comply with state law.
Well, a federal officer is not a peace officer under the definition of Colorado peace officer, Your Honor.
So is your contention that by entering an agreement that's enough to take you out of, I mean, it seems like that would render the whole be consistent with state or local law superfluous, if just by entering the agreement alone that it was valid and enforceable.
Well, the law was enacted to codify the Cisneros ruling. And the Cisneros ruling is very fact specific. The trial court in that case even pointed to a 287G agreement and said, if you had a 287G agreement, you'd have the authority to do what you are doing. Since you don't, it is an unlawful arrest. So when we say...
So I'm a little still confused about the statute, because 8 U.S.C. 1357 clearly says, and I think you stipulated on the stipulated fact in paragraph 11 that 287 program is pursuant to this statute, 8 U.S.C. 1357G.
Correct, Your Honor.
And that statute says, those who are carrying out the functions may carry out such function at the expense of the state or political subdivision and to the extent consistent with state and local law.
Yes, Your Honor.
So do you have to comply with state or local law or not?
Yes, we do, and our contention is we are complying with state and local law. Colorado law does not prohibit a 287G agreement. The statute at issue was enacted specifically for the circumstances where no 287G agreement exists.
So what about 163102? That's a state law, and it says a peace officer may arrest a person when he has a warrant commanding such person to be arrested. And warrant requires a signature of a judge.
The distinction here, Your Honor, is that that is specific to a Colorado arrest warrant.
So that doesn't apply.
It does not, because an I-200 is not a Colorado arrest warrant. An I-200 as the plaintiffs have conceded, it is a lawful federal arrest warrant.
It's a civil warrant, is it not?
It is, yes, Your Honor. And at trial, there were facts developed that a sheriff can enforce civil and criminal law. It's not just criminal.
Right. But I guess my question for you is that, assuming that a 287G agreement in general is not prohibited by Colorado law, are there portions that, I guess, if we decide that maybe some of it is, that can be excised? For example, the sheriff has general duties to, as you indicated in your briefs, participate or enforce like service of process, right? So is it your contention that the sheriff could still serve these forms? The I-200 forms, consistent with Colorado law?
Only under the auspices of a 287G program, Your Honor.
Why?
Because
Because if they had the authority to serve it regardless, and if it is a valid warrant regardless, why do they need the 287G agreement to just serve the warrant?
because of the underlying federal law, Your Honor. So the federal regulations that we've talked about authorize immigration officers to issue warrants for arrest. And then in those regulations, they may then command other certain officers to serve those warrants of arrest. And those include law enforcement officers who have been designated under a 287G program. And so the distinction there, Your Honor, is that if, I'll just go back to the El Paso scenario because that's the only other case really that we have out there. If an ICE officer sent the I-200s to the El Paso County Jail where there is no DIO, there's no authority under federal law for a detention officer to then serve that upon an inmate in that jail. So they are tied together. The authority for the immigration officer can issue a civil arrest warrant under the I-200, then can command the DIO. So plaintiffs have described the de facto federal officer component of this case as a linchpin of the case. We agree. If they are de facto federal officers, the activities that they perform under the 287G agreement are consistent with Colorado law because Colorado law does not prohibit the 287G agreement. They tried in 2019 to do that, and the plaintiffs are trying to get you to do what the legislature couldn't do in 2019. My time is up. I ask.
I have one other question.
Yes, Your Honor.
A federal ICE agent couldn't just come in and serve the warrant because there are some powers that are reserved to the states with respect to enforcement of laws, correct?
If I understand your hypothetical, Your Honor, could an ICE officer go into the Delaware County Jail or any jail and serve an arrest warrant?
Correct.
Our answer is that yes, they would be able to do so under their authority.
Under their own authority?
Under the federal authority, yes.
Okay.
But Colorado, in that circumstance, doesn't necessarily have to agree with or cooperate with. They may, but they are not required to because then we have a 10th Amendment commandeering situation.
Thank you.
Thank you.
Thank you, counsel. Bailiff, will you add the appropriate counter time to the appellant's remaining rebuttal? Thank you. I think that was 30 seconds extra. Thank you.
I'd like to see my time going up.
It's rare.
Let me start with the Colorado statute. The statute defines civil immigration detainer as a written request, it does refer to the regulation, but then it says that that includes, specifically includes, warrant for arrest of alien, which is the precise ICE form upon which the sheriff is relying. So the legislature itself has given that term a definition that this court is duty-bound to apply regardless of how it might be interpreted in any other context than this statute. So when the legislature, and we've cited the court case law to this effect, that when the Swain case and the REN case, when the legislature defines something, then you use the definition that the legislature has given you. So,
Can I ask a
yes,
question? Council says that civil immigration detainer has to be pursuant to 8 CFR 287.7, and that the I-200 form is not pursuant to 8 CFR 287.7.
that is correct. That is correct as far as it goes. So, but the legislature then went on to define what this includes. And it specifically used warrant for arrest of alien. And so the legislature has given you a definition
But is
to apply
8
here.
CFR 287.7 limiting the types of list?
It by definition, it can't be, because the statute itself goes on and says including any other ICE form.
And the warrant for arrest doesn't fall within, you're saying 287.7?
That regulation doesn't deal with warrants for arrest of alien. That's right.
Okay.
Okay, and that's why I'm telling you, you need to look at the definition the legislature's given you rather than the federal regulation, because that is what the legislature has specified. Incidentally, with respect to the term request, that was used advisedly. The legislature certainly read the Cisneros opinion. We all know that by now. That opinion included specific discussion of the 10th Amendment. Under the 10th Amendment, if these ICE forms were commands, they would violate the anti-commandeering principle of the 10th Amendment. So the term request is used there advisedly. I'd like to deal briefly with the sheriff's de facto officer argument. Again, the sheriff admits that these forms could not be used to make arrests but for the 287G agreement. And he argues that the DIOs became de facto officers. There's two problems with this argument. First of all, sections 1357G7 and 8 say that DIOs are not to be treated as a federal employee for any purpose other than those specified. But more importantly, as I think all three of you have pointed out at one time or another, 1357G1, the very statute that authorizes this program and under which the 287G agreement was entered into, says that the authority delegated to them has to be consistent with state and local law. Again, if state law forbids it, federal law doesn't authorize it.
So, counsel, I have a question then. So, I think there was a concession that the 287 agreements themselves were not outlawed by the statute. Assuming that for the sake of my question.
Okay.
If we determine that some things cannot be consistent with state law, are there some things that can? For example, the service but not arrest.
Well, we're not really talking about service. I mean, service here is used for arrest. So I don't know that we're really talking about service here. But the bottom line is that the statute says it is, to the extent it has to be consistent with state or local law. So to the extent you find that any of the activities purportedly authorized by the agreement are not consistent, then you need to invalidate it, and you need to invalidate the activities under it. Did I answer your question?
Yes, thank you.
Thank
Thank
you.
you.
Thank you, both counsel, for your excellent arguments on this interesting issue. The case will stand submitted. An opinion will issue in due course. And when you're ready to depart, counsel, for our next case, you may proceed and take your All right, great. You already heard our instructions. I know you're both well aware of them. We will call our second and final case today, and that's People versus Walters. And counsel, whenever you're ready, you may start.
Thank you, Your Honor. May it please the court. My name is Avery Lair, and I represent plaintiff David Walters. The trial court, and Your Honor, apologies, the timer hadn't been going, thank you. The trial court reversibly erred when it failed to modify, grant an evidentiary hearing, or make the required findings under Zoller to justify the continued liberty deprivation that the mandatory protection order currently has on the plaintiff's familial association with his daughter.
Okay, so let me ask you that. Obviously, no one had the benefit of Zoller, and I appreciate you both being prepared to talk about it, but familial association can be a constitutional right with at least a juvenile, like in the Troxler case, but here we have an adult daughter. So in that case, I don't know of any cases that you all cited, but what is your view on whether there is a familial association right with an adult daughter?
Your Honor, the way I read familial association is that it's association with a family member. I don't believe any of the case law cited by myself or appellee was specific just to a family member under a certain age, nor did Zoller specifically state the child must be under the age of 18. In this case, the trial court was still treating AW as a child, and the relationship between plaintiff and his daughter is still that same relationship. So certainly Mr. Walters still has that same constitutional right to a relationship with his daughter, AW, despite that she is not a minor. She is still a person, and Zoller, in fact, in the case law talked about specifically EZ, Zoller's child, but was also referenced regarding the mandatory protection order generally, as it involved EZ, and another person was on the protection order as well, an adult.
Right, but it's not a constitutional right under any and all circumstances, correct? Which is part of the issue, is, I guess, what's your argument about whether there's some other method or something differently the court should have done to be kind of least restrictive?
Thank you, Your Honor. Yes, that's correct. It's not a constitutional right under every circumstance to have all types of contact, certainly. And that's not what we are asserting. Zoller was very clear that for a mandatory protection order provision to survive a constitutional challenge, the district court must find that, one, it's justified by compelling circumstances, and two, the purpose of the order cannot be accomplished by less restrictive means. In this case, the court outright denied any means for Mr. Walters to contact AW. AW had a unilateral ability to write to Mr. Walters, and that's been the same kind of order, standing order, since 2015. To answer the court's specific question, the trial court could have fashioned any number of abilities. At the time that the motion was filed in 2022, Mr. Walters was in the Department of Corrections. Therefore, all contact certainly would be monitored by the Department of Corrections staff, as inmates are subject to phone monitoring, letter monitoring. Certainly the court may say, I need a third-party supervisor to monitor these. The court also could say that the contact needs to start at written contact. The court instead posed no middle grounds and outright said no contact can happen unless it's recommended by AW's therapist.
Do you think it might have been more appropriate, or at least, well, let me guess, do you think it might have been more appropriate to not to restrict AW, but to fashion some sort of limit or restriction with respect to your client as to what he had to show to address any of the court's concerns?
Sure, certainly that could have been fashioned by the trial court to create a less restrictive less restrictive means, as the court said. But instead, the court said outright no, unless they had a recommendation from AW's therapist. AW explicitly, as as I'm sure this court saw throughout the court file, wrote she did not want a therapist. She did not want to see one. She wanted to have this contact, as is her right not to see a therapist. And instead, the court created this requirement in 2015 and has not revisited that, despite the passage of time, despite the fact that AW is now nearing 30 compared to when she was 17 when the offense happened in this case. And those factors are certainly very relevant, and factors the court has completely disregarded in this particular case. And it is directly against what People v. Zoller stands for, which was recently decided before this same court. So, Your Honor, the first reason why, as was stating, this court should find that the trial court was wrong was due to the Zoller case. As was stated, to survive a constitutional challenge, the district court must find, first, it's justified by compelling circumstances, and second, the purpose of the order cannot be accomplished by less restrictive means. Here, the trial court did not make those findings when it denied appellant's motion in 2022, and arguably had not made those findings throughout the duration that these protection order modifications have spanned years before this court. First, regarding compelling circumstances. In Zoller, the court specifically...
Can I just
yes, Your
ask, the relief you're requesting is
Yes.
for us to remand for an evidentiary hearing and for the trial court to apply Zoller?
That's correct, Your Honor. And in addition, certainly would request that this court orders the court to modify the protection order to permit conduct. But
We can't do that, can we? I mean,
Your Honor,
we have to remand it for the trial court to do.
that's correct. People v. Cooley, which was cited in the motions, stated in that particular case at this time the trial court was not prepared to modify the protection order, but did not say an outright bar against doing so. There is certainly not an ample amount of case law about this particular issue before the court, so we would advocate certainly this court could consider doing that, but at a minimum would be requesting for this court to remand, allow an evidentiary hearing, and make findings consistent with Zoller, similar to what Your Honor just stated. Thank you.
Well, you would agree, though, that even under the cases you're citing, that there are certain factual determinations that need to be made. So we don't find facts. There's really no way for us to just order a protective order. I mean, you would agree with that?
Certainly, Your Honor, which is why primary request is certainly for this remand to make the evidentiary findings, which we had requested in the initial motion before the trial court, which the trial court did deny because it is a very fact-specific determination. However, because the case law is silent on this issue, and because this court certainly does have a lengthy court record, all of the pleadings before it certainly would make that request as well, but heavily request this remand as requested and the request for the evidentiary hearing to make those fact-specific findings. Thank you. So, Your Honor, regarding the Zoller case and why it is so applicable to this particular case, first, the court in Zoller specifically stated that it must be justified by compelling circumstances, the existence of this continuation of the mandatory protection order. In this case, the court did not make any findings regarding that. The court was silent as to that. The court only stated that it was basing its ruling off the 2015 finding that AW needed to provide documentation from a therapist. Certainly, Your Honor, another compelling circumstance which would weigh in an appellant's favor is certainly the passage of time, which also is highly relevant in the People v. Bear case as well. The People v. Bear case discussed that was a 12-year-old offense. This case is very comparable to that, and that the allegations in this case happened in 2013. And certainly that would be a relevant consideration regarding the compelling circumstance, which would weigh in plaintiff's favor. As this case did happen in 2013, and we are still operating off a protection order stemming from January 7th of 2015. Additionally, Your Honor, therefore, due to the lack of the court, therefore, Your Honor, if there is a remand in this particular case, it's highly likely the court would not be able to find those compelling circumstances that are needed to find in the Zoller case. Secondly, Your Honor, as Your Honor already posed the...
Counsel, I'm going to stop you there.
Thank you.
I think part of the people's argument is that in and of itself, the allegations in this case for which your client was convicted are compelling circumstances. Can you speak to that?
Thank you, Your Honor. Certainly, appellant is not diminishing the circumstances in this particular case. They were serious. They were involving the individual that we are discussing the protection order regarding. That being said, they did happen almost a decade ago. There have not been any repeat offenses. There has also been no mention of any further violations of this protection order or any such factors, and those are all factors that will be considered as part of the compelling circumstances as well. Secondly, Your Honor, would certainly advocate that the trial court failed to find any less restrictive means in this particular case. The trial court did not pursue or consider any less restrictive means in its order. It only found that the court will reconsider if recommended by a therapist, again citing this order from 2015. There was no finding that a complete prohibition on Mr. Walters contacting AW until AW received therapy was a less restrictive means of promoting safe contact. Certainly, as was preserved and presented in both the opening brief and the motion to modify the protection order, at the time of the initial motion, as was discussed, Mr. Walters was in the Department of Corrections. Therefore, certainly any contact, letters, phone communication could be monitored and would certainly be a less restrictive means than outright full contact. Failure for the trial court to make these findings or considerations did constitute a due process violation. Mr. Walters has the fundamental right to this parental association. To protect that right, this court has found that those particularized findings must be made, which were not happened in this case. Your Honor, certainly the due process claims, despite that Zoller was decided after briefing had concluded in this case, certainly the due process claims were well preserved in this particular case. As Mr. Walters certainly argued that he did not receive procedural or substantive due process in this case when the trial court issued its ruling outright denying Mr. Walters' motion without a hearing. And Your Honor, I would just request to reserve my remaining time for rebuttal. Thank you.
Absolutely. Thank you.
May it please the court, my name is Jacob Lofgren, registration number 40904, and I represent the people in this matter. We ask this court to affirm because the trial court properly denied Mr. Walters' most recent request to modify the mandatory protection order entered at the time that he was charged.
Mr. Lofgren, let me ask you really quickly, because as I read this statute, a hearing was required.
Yes, and when I was prepping for this argument, I saw subsection 6 as well, which I think both myself and opposing counsel overlooked in our briefing. It does appear that by statute, a hearing would be required, and I would agree that if any remedy is offered in this case, it would be a remand for that hearing.
So if we were to remand for a hearing, we wouldn't have to reach any of the constitutional issues or the due process issues.
That's correct, and I think Zoller also supports that proposition. I would say I don't believe there has been a procedural due process constitutional violation here. If anything, it was at most a statutory violation. And I think the record as a whole supports the trial court's denial of the motion to modify. The first thing I wanted to do before I turn to the compelling reasons and least restrictive means is address your question about family and whether it makes a difference that AW is now an adult. And I think the answer is no. And what informs my answer there is looking at the fact that mandatory protection orders like this are used all the time in domestic violence cases. And often the reason for them in those cases is protection of the victim from themselves, from returning to the situation where they were victimized. That's the exact same situation we have here, where the victim is asking to reinstate a relationship that perhaps would result in re-victimization or certainly further mental harm, or at least there hasn't been a demonstration that it wouldn't result in further mental harm.
But
So
I'm sorry.
Go
Mr.
ahead.
Lofgren. My question is, why is that onus not on the offender? Why wouldn't that be a less restrictive means of trying to accomplish what the court was apparently trying to accomplish under the protection order? Put the onus on the defendant to show something if he's asking to modify the protection order.
And I think the court is trying to put the onus on the defendant. The problem here is the only person who can show this wouldn't result in more damage to the victim is the victim. And the only way to do that, as the court has described, is through some kind of professional counselor or someone indicating reinstating this relationship at this point is not going to result in further damage. And I think that is especially appropriate in this case if we look at what has happened at the time of the offense and going forward. This offense was a father who committed heinous sexual offenses on his daughter, resulting in her impregnation. Worse than that, in the years that followed, the defendant is filing letters with the court saying things to the effect of, "She wanted this. She asked me to do this. I'm sorry that I participated in her request." There has been no indication at any point of remorse or accountability. And that is what is underscoring the court's repeated denials of this request to modify the protection order. This isn't a father who is seeking to reestablish a proper relationship with his daughter. Rather, is it a father who is given every indication that he believes his past wrongdoing was not actually wrong. This is the exact type of situation where we want a protection order in place to prevent re-victimization or at least further damage to the victim.
Shouldn't all those arguments be made in the district court if we want to hear, Mr. Zoller was denied a hearing pursuant to the statute?
And I think that's spot on. I think these are the arguments that will be made below if this is remanded. But I also think they are well fleshed out in the existing record, and this court could look to that in determining whether there is sufficient information to support them.
But the trial court didn't apply the Zoller framework, so
That-
should we tell them to do that?
That's correct. And I would agree that if any remedy is appropriate here, that is the remedy, if it is anything aside from affirmance. And I did just want to briefly touch on the Zoller framework with the compelling circumstances and the less restrictive means. The compelling circumstances, as Judge Moultrie identified for my brief here, is the offense itself. And Zoller provides some support for the idea that the offense itself can be the compelling circumstances. What we have here are facts that are even more egregious than Zoller. The victim is the person that is protected by the mandatory protection order, and the offenses committed on the victim were far more egregious than the offenses committed on the subject of the protection order in Zoller. Second, at the time that the trial court accepted the plea agreement and sentenced the defendant, it made extensive findings in rejecting a request to modify the protection order. I think those findings, had they been made at every step of the process and every subsequent request, would have been sufficient. And I think this court could look at them in assessing the entirety of the record as it relates to this most recent request. Amongst those findings, the court noted grooming behaviors that were ongoing. The court noted that the family, the extended family, had continued to cover for the defendant since the offense occurred, and that there was a constant lack of accountability and blame shifting that I already discussed. Regarding the less restrictive means, the court did do one modification in this case, and it allowed the one-way contact from the victim to the defendant. That was the least restrictive means the court could see fit without risking further damage to the victim's mental health. Absent some indication, something provided by the defendant that there would be no further damage, the court said, "I'm not going to modify," and that was perfectly appropriate. If the court has no further questions, I think I've covered Zoller, and I've acknowledged that a remand is probably the appropriate remedy here if affirmance is not appropriate.
Thank you.
Thank you.
And I appreciate your candid assessment of the statute.
Thank you.
Thank you, Your Honor. I will make my response brief, given Mr. Lofgren's, agreement that remand is probably appropriate in this case. Just to briefly state, he did reference that the findings from the past would be sufficient for today's hearing. I would advocate in the grooming behaviors. I would just remind this court that the requests essentially by appellant himself did stop in 2016, so still several years ago, before the most recent filing by counsel in 2022. Certainly also, there are a lot of changed circumstances that are quite compelling as of today's, namely also the age of AW, her continued growth and maturity is certainly relevant, and all these findings certainly can be discussed should a remand be granted today. Thank you unless the court has any additional questions for me, I want to thank Your Honors very much. Thank you.
Thank you. Thank you, both counsel, again, for your very helpful arguments. As you know, the case will stand submitted. An opinion will issue in due course. That concludes our 2 o'clock docket for today, and the court will stand in recess. Bailiff, you may so announce.
All rise. court will be in recess, subject to call.